I welcome you again to the library's second presentation in our lecture series in celebration of Black History Month. On June 25, 2013, the U.S. Supreme Court in Shelby County v. Holder struck down Section 4B of the Voting Rights Act of 1965. Known as the preclearance formula, this section barred 9 states and parts of 6 with a previous history of discriminatory practices from making changes to their elections laws without prior approval from either the Justice Department or a federal court. Since the High Court's 2013 decision, has there been a rise in the adoption of state laws restricting minority access to the polls? This evening, I'm honored to introduce a recognized expert on the Supreme Court and judicial interpretation, Jeffrey Rosen, President and CEO of the National Constitution Center, as well as Professor of Law at the George Washington Law School. Chartered by Congress in 2003, the National Constitution Center, which is located in my hometown of Philadelphia, is the only federally established entity dedicated to sharing unbiased information about the supreme law of the land. Mr. Rosen took charge of the center in 2014. Our distinguished speaker earned his bachelor's degree from Harvard College in 1986, a second bachelor's degree from Oxford University in 1988, where he was a Marshall Scholar, and his law degree from Yale Law School in 1991. After law school, he clerked for Chief Judge Abner Mikva of the U.S. Court of Appeals for the District of Columbia. Since 1997, he has taught constitutional law and other courses at the George Washington Law School. Since 2000, he has also served as a moderator at the Aspen Institute, where he conducts seminars on the Constitution, privacy, and free speech. In addition to his more than 50 law review articles, Professor Rosen is the author of 5 books that include the critically acclaimed volumes, The Supreme Court, The Personalities and Rivalries That Define America, and The Most Democratic Branch, How the Courts Serve America. And by the way, we do have those books in our collection. His 6th book about Supreme Court Justice Louis Brandeis is currently under contract. Professor Rosen has received numerous honors. The LA Times called him, quote, one of the nation's most widely read and influential commentators, unquote. The Chicago Tribune named him one of the 10 best magazine journalists in America. In 2012, he received the Legal Writing Institute's Golden Pen Award for contributions to legal writing. Produced in cooperation with the Constitution Center, the series explored human stories and legal issues surrounding the most important high court decisions that have impacted America. Without further ado, let's welcome Mr. Rosen as he comes forward to discuss the impact of the court's 2013 decision with respect to voting participation. Thank you.
Thank you so much, Paul. It is wonderful to be back at the DC Public Library. I had the honor of being here, when was it, 2000? 2010. And we had a great talk, and you heard last night from my wonderful GW colleague, Chris Bracey, who's just so good on these issues. So I'm hugely honored to be here. So the topic is, what are the post-Shelby County challenges to voting rights, and what can we expect when it comes to the future of the Constitution and voting rights? And in order to address that topic, and I promise I will take up the homework assignment that Paul gave me, we also have to review the history of the 15th Amendment to the Constitution, which extends the right to vote to African Americans. Now, this is a very good time to be talking about the 15th Amendment because on February 3rd, 1870, that's 146 years ago yesterday, the 15th Amendment was ratified as part of the Constitution. And the National Constitution Center, which, as Paul said, is on Philadelphia, on Independence Mall, right across from Independence Hall, with the most inspiring constitutional views in America, we're spending the next 5 years celebrating the 150th anniversaries of the 13th, 14th, and 15th Amendments to the Constitution. Those post-Civil War amendments that ended slavery and guaranteed equality and promised the right to vote to African Americans and to all well, just to African Americans. And we will review their history, their contemporary meaning, and what we're going to do is bring together the best voices on all sides of the constitutional debates. This is called the Second Founding Initiative, and the National Endowment for the Humanities has supported it. We had a launch at the National Archives on the 150th anniversary of the 13th Amendment, and for the next 5 years, in Philadelphia, at the Constitution Center, here in DC, and online, you're going to hear the best thinkers on all sides of these debates and you can talk about their contemporary relevance. The best place to start is an incredible new online tool that I want to tell you about, and that is called the Interactive Constitution. And you can find it at constitutioncenter.org. And here's what we've done. With the help of the American Constitution Society, which is the leading progressive lawyers organization in America, and the Federalist Society, which is the leading conservative lawyers organization, we've assembled the best scholars from both sides of these crucial debates to write about every clause of the Constitution, describing what they agree about and what they disagree about. So you can click on the 15th Amendment, which we're going to talk about today, and see the top liberal and conservative scholar with a common statement about what they agree its meaning is, and then separate statements about where they disagree. And it's such an exciting nonpartisan tool. We're going to bring it to every school kid in America. We're bringing underserved kids from the Philadelphia public schools into the Constitution Center to use it. The College Board is going to bring it to every classroom in America. And I just think it's a thrilling way of educating all citizens about the history and meaning of these amendments. Because we have an obligation to teach ourselves about these amendments. That's why you're all here tonight. You've taken time to learn about what the framers of these amendments were trying to achieve, to find out how the courts initially stymied and thwarted the hopes of these amendments, and then to talk about some current controversies about them. So let me begin first by reading the text of the 15th Amendment, because it's always a good idea to begin with the text. You can find it at the Interactive Constitution. You can find it in wonderful online pocket constitutions like this beautiful National Constitution Center copy with a completely thrilling introduction by yours truly and David Rubenstein about the relationship between the Declaration of Independence and the Constitution and the Bill of Rights. And in many ways, the little introductory essay here sets up our topic today, because what we're really talking about is how the promise of equality in Jefferson's Declaration, Jefferson's inspiring promise that all men are created equal, which was thwarted by slavery and by the compromises that were necessary to adopt the original Constitution, how that promise was thwarted by the original Constitution, and it took Lincoln's promise at Gettysburg of a new birth of freedom, the bloodiest Civil War in American history, and then these three beautiful post-Reconstruction amendments to the Constitution to make Jefferson's promise more of a reality. All right, so let's begin with the text of the 15th Amendment. Here's what it says. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The Congress shall have the power to enforce this article by appropriate legislation. This is a hugely significant amendment, and it was tremendously controversial in its day. Remember, this is the last of the three Civil War amendments. The 13th Amendment, ratified 150 years ago last year in 2015. The 14th Amendment in 2018. Thank you very much. Let's go back to the 19th century and start again. 13th Amendment, 1866. 14th Amendment, 1868. 15th Amendment, 1870. The 15th Amendment is so controversial, the idea of giving African Americans the right to vote is so controversial, that when Lincoln stood at the White House in March of the year he was assassinated and said, "I am determined to bring the right to vote to African Americans," John Wilkes Booth was in the audience, and he said, that statement is Lincoln's last. It was the promise of the right to vote to African Americans that really inflamed Booth into committing the dastardly act of the assassination. And the right to vote was so controversial that there were not enough votes to enshrine it in the Constitution, either in 1866, when the 13th Amendment abolished slavery, or in 1868, when the 14th Amendment promised to all persons equal protection of the law and no deprivation of life, liberty, or property without due process of law. We know that because Section 2 of the 14th Amendment, which many of the Reconstruction Republicans thought was the most important in the bunch, said if Southern states deny the right to vote to African Americans, which we expect they're going to do, then they have to have a corresponding reduction in their apportionment in Congress, because these Reconstruction Republicans didn't want these Southern states to essentially deny African Americans the right to vote, but then get an electoral majority and get the benefit of their representation. So it took the 15th Amendment to promise the right to vote to African Americans. But what happened after this noble promise was enshrined in the Constitution? Well, the initial history is a sad story, both of undermining this promise by judges and by the racist state legislatures that adopted so many ruses to deny the promise of the 15th Amendment. In order to sum up the essence of the 15th Amendment, I can do no better than to read from the common statement that the two scholars on our interactive Constitution agreed on to describe it. So this is Richard Pildes from NYU and Brad Smith from Capital Law School, leading liberal and conservative scholars of voting rights. Every word I'm about to read are words that they both agreed on. So this is consensus history. No one disagrees that this was the basic point. Added to the Constitution in 1870, the 15th Amendment was the final of the three constitutional amendments enacted during Reconstruction in the aftermath of the Civil War. Though its express terms prohibit all racial discrimination in voting qualifications, the amendment was aimed at ensuring the enfranchisement of African Americans. Section 2 of this short but momentous amendment also gave Congress the power to enact legislation to enforce the right against race-based denials of the right to vote. The constitutional meaning of the Civil War was reflected in these three amendments, and former slaves are now entitled to political equality. But the most significant fact about the 15th Amendment in American history is that it was essentially ignored and circumvented for nearly a century. This history illustrates that constitutional rights can be little more than words on paper unless institutions exist with the power to make sure these rights are actually enforced. For the first 20 to 30 years after the amendment was adopted, black adult men, women were generally not permitted to vote at this time, were indeed permitted to vote and did so in large numbers. Nearly 2,000 African Americans were elected to public offices during this period. But starting in 1890, Southern states adopted an array of laws that made it extremely difficult for African Americans and many poor whites to vote. This was the start of what is known as the era of disenfranchisement, and it lasted all the way until 1965. These laws required people to demonstrate literacy, or prove their good character, or pay certain voting taxes, or overcome other hurdles before they were permitted to vote. As a result of these laws, African American voting in the South was kept at extremely low levels from 1890 to 1965, despite the 15th Amendment. That sorry history no one can dispute. As I said, that was signed by the leading liberal and conservative scholar, and they both agree what's clear from the history, which is that after this very brief initial period between 1870 and 1890, when African Americans were enfranchised, the combination of racist state action and also Supreme Court decisions made that noble promise a hollow one. So just let's review some of the big cases that thwarted the promise of the 15th Amendment for most of American history, because the courts really did play an important role in the elimination of African American suffrage. The Supreme Court refused to enforce the few federal protection for African American voting rights that had survived Reconstruction. And remember a little bit of this history here. So there's this initial period after Reconstruction where it looks like African Americans can vote, but in the infamous Compromise of 1876, Republicans agree to end the enforcement of Reconstruction in the South, and Democrats acquiesce in this in exchange for allowing Rutherford Hayes, who'd lost the popular vote but won the electoral vote, to get into the White House. So the Democrats make this corrupt bargain. Hayes won the popular vote, but they say, okay, we're not going to press this objection as long as you Republicans stop enforcing voting rights and Reconstruction in the South. And because of that corrupt bargain, that's what allows, starting in for real in the 1890s, both the extension of Jim Crow, of separate but equal, codified in Plessy versus Ferguson, and then the steady and sad destruction of African American voting rights. And then there are all of these Supreme Court cases that say, Southern states, you're going to adopt these ruses to stop African Americans from voting. They're perfectly constitutional, despite the promise of the 15th Amendment. So here are some of the big cases. A case called United States versus Reese in 1876 actually strikes down parts of the 1870 Federal Enforcement Act that prohibited discriminatory administration of voting qualifications by state officials. So the Reconstruction Congress passes a federal law telling state officials not to discriminate. The Supreme Court strikes that down as being beyond Congress's power to pass. And then in the early 20th century, after the commitment to Reconstruction collapses, the court upholds other state efforts to disenfranchise African Americans that violate even the narrowest original conception of the 15th Amendment. In the most dramatic confession of judicial impotence in the face of local intransigence, the court, in a case called Giles versus Harris, 1903, I want you to remember this one, refused to stop Alabama's massive and successful effort to disenfranchise qualified black voters. White voters who registered before 1903 are considered registered for life, while black voters who applied after that date are subject to a series of more severe tests. The author of that infamous Giles opinion, none other than Justice Oliver Wendell Holmes. He's often considered a progressive hero because he dissented in cases striking down maximum hour laws for bakers, but he was no progressive, and basically his view of the Constitution was so nihilistic that he thought that the majority should be able to impose its will on the minority or else open warfare would result. So even though, despite the explicit text of the 15th Amendment, which promises the right to vote, Holmes says we, the court, are powerless in the face of this massive and obstructionist effort by Alabama to disenfranchise African Americans. This goes on during the Progressive era. There's a case called Gwynn versus United States from 1915, where the court does strike down an Oklahoma grandfather clause that gives an exemption from literacy tests for only citizens who'd been on the rolls in 1866 when no blacks were eligible. So there were one or two favorable cases in that period. But it really wasn't until the 1940s that a favorable political climate helped the Supreme Court begin to increase black suffrage by striking down all white primaries in cases like Smith and Albright from 1944. Why did this happen? Why is the Supreme Court, after decades of intransigence, suddenly begin to rediscover the 15th Amendment? Well, partly it's because African American servicemen are returning from World War II. They're determined to protect their rights. They've served side by side against with white soldiers who are suddenly beginning to come around. Jackie Robinson is integrating Major League Baseball. The whole climate of the country is finally beginning to change, and the Supreme Court reflects those changes. Southern whites are less determined to resist. Federal prosecutors are more willing to threaten resistors with prosecution. As a result, Southern judges can finally be persuaded to construe voting rights broadly rather than narrowly. But it wasn't until the passage of the Voting Rights Act in 1965 that African Americans in the South begin to be meaningfully enfranchised. Congress abolishes literacy and good character tests and authorizes federal officials to supplant local officials who refuse to register blacks. And the president backs that decision with federal force. So this is a really remarkable history, and it's a troubling history. It's a history of how Americans fight a civil war, the bloodiest in American history. It's crowned by the promise of voting rights for African Americans, but because of political compromise and judicial complacency and complicitness, that promise doesn't begin to become a reality until 1965. Well, with that history on the table, what does that say about the constitutional debates that are riveting the country today involving the future of voting rights, especially the cases that Paul asked me to talk about, those that followed the Supreme Court's Shelby County decision in 2013. Well, let's review what the Shelby County case held. As Paul properly said, it invalidated Section 4B of the Voting Rights Act of 1965. Section 5 of the Voting Rights Act required all covered jurisdictions to get approval from the Justice Department before changing their voting procedures. And it defined eligible districts as those that had a voting test in place as of November 1st, 1964, and less than 50% turnout for the 1964 presidential election. And if a district is covered, it had to prove to the Attorney General or to a 3-judge panel in D.C. that the change didn't have the purpose or effect of negatively affecting any individual's right to vote based on race or minority status. So those two sections were in place between 1965 and 2003. And the Section 4 formula that the Supreme Court struck down in 2013 covered the following states: Alabama, Alaska, Arizona, Georgia, Louisiana, Mississippi, South Carolina, Texas, Virginia, and parts of California, Florida, Michigan, New York, North Carolina, and South Dakota. These are all areas that had shown race discrimination in their voting processes, and they met the original standard for being covered by the Voting Rights Act. But the basic argument of the Supreme Court agrees with Alabama that that basically Section 4 of the Voting Rights Act is unconstitutional because the coverage formulas are no longer relevant and impose burdens that are not responsive to current conditions in the voting districts in question. The Supreme Court said the formula was based on data that was more than 40 years old. It was out of date, did not reflect current conditions in the country. But the court said, Congress, you can fix this by drafting another formula based on current conditions. Chief Justice Roberts writes for the 5-4 majority. He says, our country has changed, and while any racial discrimination in voting is too much, Congress must ensure that the legislation it passes to remedy that problem speaks to current conditions. In her very vigorous dissent, Justice Ruth Bader Ginsburg said, voting discrimination still exists, no one doubts that, but the court today terminates the remedy that proved to be best suited to block that discrimination, the Voting Rights Act of 1965. So you understand the gist of what went on before that Shelby County case. If a state that was on the list that I read, starting with Alabama and including all those other southern states and some northern one as well, changed their voting procedures in a way that negatively affected African Americans, then they had to get approval in advance from the Justice Department or from judges. Now that that's struck down, they can make those changes without getting that approval. And that's what's led to the explosion of new laws that I'm going to talk about in a moment. But it's important to remember one thing. Although that preclearance provision, Section 5, is struck down, there's another part of the Voting Rights Act that survives. A little technical, but it's important to get these straight because this is what the future of Voting Rights Act is going to involve. This is called Section 2 of the Voting Rights Act. That remains in place. That forbids policies that result in a denial or abridgment of the right to vote based on race and calls for a judgment based on the totality of the circumstances. But here's why it's harder to bring a successful Section 2 challenge than it was under the old Section 5. A Section 2 challenge can only address existing laws. You don't have to get approval in advance if you're going to change the voting procedures. And the burden of proof is on the plaintiff, meaning that the suits are really expensive to bring. And so far, federal courts have diverged a lot on the question of what constitutes a practice that results in an abridgment, and there's very different views on exactly what the Voting Rights Act forbids. So, as Paul said, after Shelby County, states that are previously considered covered are free to change their election laws, and they've done precisely that. Many states have passed laws to change their voting practices. At least 20 states now have laws on the books allowing for online voter registration, which sounds like a expansion of voting opportunities, but there have been many laws in the opposite direction. 16 states have passed other laws regarding the right to vote, and others have shifted early voting and voter registration times and enacted voter ID requirements. It's not just the former Section 5 states that have enacted these changes. Ohio, for example, cut down on early voting, eliminated Golden Week when voters could register and vote at the same time before Election Day, and these laws are continuing to proliferate. So how can we sum up what's going on post-Shelby County? I'm going to read from the separate statement of Richard Pildis on the Interactive Constitution. He was the scholar nominated by the American Constitution Society, and here's what he said about these post-Shelby requirements. In virtually every state that's enacted new requirements for proof of eligibility to vote or cut back on access to voting, the laws were passed on straight party line votes. Republicans vote in favor of these laws, Democrats against. That has given an intensely partisan political cast to these constitutional controversies as well. Critics of these laws argue, one, there's no significant need for new laws concerning proof of citizenship or identity, because there's no real evidence that under the previous longstanding laws, voters who were not eligible were actually voting. Two, these laws are likely to suppress voting and make it more difficult for eligible voters to vote. And three, these laws are passed for partisan purposes because those more likely to vote Democratic are less likely to have the relevant documents, even when they're eligible to vote. Proponents of these laws, by contrast, argue that they help ensure the integrity of the political process, and they're not based on an intention to discriminate African Americans, whether or not they have that incidental effect. And that's the crucial question, because to survive a constitutional challenge under the 15th Amendment, you have to prove that the laws were intended to discriminate. And if you can prove that they were intended to increase the partisan representation of Republicans, then that's a partisan purpose, not a racial purpose, and the constitutional challenge can't survive. So as a result, there's a big dispute about whether these laws are actually legitimately combating voter fraud and protecting the integrity of the democratic process, or whether the real goal is to limit the right to vote, mostly among low-income and minority voters who may not have a government ID or have enough flexibility with their employment to vote on Election Day. Since 2010, new voting laws that curtails voting options has been put in place in 22 states. According to the Brennan Center, and there are lots of legal challenges to these laws in states ranging from Arizona to North Carolina. I want to focus now on the North Carolina challenge, because in many ways it's the most important of the post-Shelby County cases, and it's about to be decided. A decision is expected as early as March, so we need to pay close attention to this case. It's called North Carolina NAACP versus McCrory, and it was brought only a month after the Shelby County case basically nullified the preclearance requirements in the Voting Rights Act. During that month, the North Carolina General Assembly moved to enact a host of new voting laws. On August 12, 2013, the North Carolina Governor, Pat McCrory, signed into law this bill, which imposes strict voter ID requirements, eliminates same-day voting registration, reduces early voting opportunities by reducing the number of days of early voting, prohibits the counting of provisional ballots by voters who go to the wrong precinct, and expands the number of poll observers and people who can challenge ballots. The North Carolina NAACP sues, arguing that this law violates Section 2 of the Voting Rights Act and the 14th and 15th Amendments. And remember, I said that's the section that's left to actually bring these challenges. There was a trial on the photo identification requirement that began on January 25th of this year, just last month. There were closing arguments on February 1st, just a few days ago, I guess last week, and there's a decision expected as early as next month. So this is moving pretty fast. On January 15th, the judge in the case denied a preliminary request by the NAACP to block the law from going into effect until after the March primaries. This means that voters do have to show a photo ID beginning with early voting on March 3rd, and this law will have significant effect on the upcoming elections. The Washington Post reported that during the recent oral argument on the voter ID laws, an attorney for the NAACP, Michael Glick, said in his opening statement, the state should be making it easier for people to engage in the fundamental right to vote, not harder. Because the voter ID requirement will make it harder for African Americans and Latinos to vote, he said, it's unconstitutional and also violates the Voting Rights Act. Thomas Farr, the lawyer representing North Carolina, said there's no evidence that any resident of the state will be unable to vote under the photo ID law, and he said there's a great deal of dispute about the data the NAACP and the Justice Department will present, which they say indicates that African Americans are twice as likely as white voters to lack a photo ID. The voting rights expert Richard Hassan has said about the importance of the case, election administrators, voting rights activists, and lawyers are watching the North Carolina case very carefully. If North Carolina gets a green light from the federal courts to pass this set of laws, making it harder to register and vote, I expect other states with Republican legislators to pass similar laws. So this is a big case. I think we should briefly review the arguments on both sides just so you have a sense of what they are and can evaluate them as you look at these cases moving forward. So the North Carolina NAACP says, yes, it's true, Shelby County struck down that section 4B, requiring preclearance for those covered states. But the court in the Shelby case made clear that its decision in no way affects the permanent nationwide ban on racial discrimination in voting found in Section 2 of the Voting Rights Act. And here the claim is that there is a violation of Section 2 because although the qualifications are what the lawyers call facially neutral, in other words, they don't say, hey, African Americans, you can't vote, they have a disparate impact on African Americans, and because of the existing conditions denying African Americans equal and meaningful access to the political process. And the test for Section 2 is, does the voting qualification and access deny minority voters the ability to participate meaningfully in the political process? The NAACP also said there's a constitutional violation because these are unlawful burdens on the right to vote that are not justified by legitimate or compelling state interests. And finally, they say there are irrational and unjustifiable distinctions among different classes of voters. The constitutional law gives the courts a lot of discretion to decide what kind of burdens are reasonable and what kind of interests are compelling. So the constitutional standard is rather malleable. The NAACP says it's not reasonable because the voter ID laws requires registered voters to show a government-issued ID, This will disproportionately injure African Americans who are less likely than other voters to have the required forms of IDs and find it harder to get them. The same-day voting registration and early voting procedures will also disproportionately injure African Americans who use these procedures at a higher rate than white voters. By expanding the number of poll observers and numbers of people who can challenge ballots, the law increases the likelihood of voting harassment. North Carolina legislators attempted to justify the law by pointing to concerns of voter fraud, but the NAACP says the facts establish that voter fraud isn't a significant problem in North Carolina, and even if it were, there are better ways to address it. In other words, the law does impose a substantial unlawful burden on the right to vote. The United States, in other words, the Justice Department also filed a brief in this case, so it's very interested in it, and it made arguments of its own. The U.S. said the history of official race discrimination against African American citizens in North Carolina is long-standing. The law reduces the days of early voting, which African Americans disproportionately used in recent elections. There's been a big rise in voter turnout in recent years in African Americans. In fact, African American turnout surpassed that of white voters in 2008 and the 2012 general elections, and that trend was due in large part to early voting. African Americans also disproportionately used same-day registration during the last two presidential elections, but the law prevents counties from counting provisional ballots if you don't vote in your home precinct. Finally, when it comes to the voter ID law, of the 4.5 million white registered voters in the state, 3.8% appeared not to have official DMV-issued identification, whereas of the 1.4 million African American registered voters, 7.4% didn't have that same kind of DMV-issued identification, and that's the argument for why the law disproportionately affects African Americans. The United States, in its brief, also argues that the legislative history shows that even North Carolina officials themselves predicted it would have negative implications for minority voting in the state. Before the governor signed the law, the North Carolina Attorney General, Cooper, urged the governor to veto it, saying the bill was regressive and would make it harder for working people to vote during early voting periods. He also criticized the provision prohibiting the counting of provisional ballots cast outside of the voter's home precinct, and he described the new voter ID requirements as unnecessary, expensive, and burdensome. The state legislature acknowledged in 2005 that the failure to count out-of-precinct provisional ballots would disproportionately harm African American voters. This proves, the United States argues, that the law was enacted with the purpose of denying or abridging the right of African Americans to vote on account of their race or color, with knowledge of the disproportionate effect that its provisions would have on the equal political participation of minority voters. Of course, there's a response from North Carolina, and here's what it is. North Carolina, in its brief, admits the public statistics cited in the complaints about the number of African American voters in previous elections, as well as the methods by which African Americans previously voted, such as early voting. North Carolina also admitted it had a history of racial discrimination in voting. But, the state argued, the law's anticipated impact on African American voters is merely speculative, which doesn't suffice for a legal claim under Section 2 of the Voting Rights Act. The state argues that the plaintiffs are trying to impose on Section 2 the old analysis that the court struck down under Section 5 of the Voting Rights Act by using that preclearance formula. And in this case, I know this is technical, but this is the heart of the legal dispute. While the plaintiffs alleged that there were disproportionately high participation rates in the early voting, which might have proved a diminished ability to vote in a Section 5 proceeding, these allegations have no relevance to the question of whether the law actually causes minority voters to be deprived of an equal opportunity as compared with all other voters to register and vote. So let me just try to restate that in English. The state is basically saying, yes, we agree, if you offer these statistics under the old formula, you might win because it's harder to vote, but that doesn't prove that minority voters are denied a meaningful opportunity equally to participate in the political process as compared with other voters. And they're saying to prove that, it's speculative because you don't know what the effect of these new procedures are because they haven't been tried yet, and you can only challenge the procedures based on evidence of their prospective effect. That's why it was so important, the challengers argue, to have the old laws in place, because then you could challenge a proposed change in procedure based on its anticipated effects. You didn't actually have to present data proving the effects before the fact. So with that in mind, you have a sense of the legal landscape moving forward. You see how much harder it is to prove a voting rights claim under Section 2 of the Voting Rights Act than it was under the old system. There are a bunch of other cases pending, similar challenges to voter ID laws. in cases like in Pennsylvania and also in Wisconsin, and we can talk about those cases if you like a little bit. But I want to conclude, and then I'd like to have a discussion with you. What I've tried to argue is that the history of voting rights in America is a troubling one constitutionally, that after the grand promise of the Civil War and of the 15th Amendment and a brief period when African American enfranchisement and voting became a reality, that promise was systematically thwarted by political resistance and by the courts. Once again, there was a resurrection of promise with the Voting Rights Act of 1965 and a period of meaningful enforcement, but that the new challenges on the horizon after this Shelby County case, which ranged from new voter ID requirements to the end of early voting to other requirements that, although facially they don't mention race, have a disproportionate impact on African Americans, may, for the reasons I've described, be harder to challenge in court. Thank you so much, and we'd love to have a discussion about these important questions.